Hello, good morning. Good morning, everyone. I hope everyone's doing great today. Um, I'm going to wait for people to join me, but I have a really great topic. And as always, my topic is something that came to me based on certain trends I'm seeing. So I figured this would be a good time to discuss all of this. My name is Ifeoma Odunlami. I am an immigration attorney from the Odunlami Law Firm in New Jersey. And although our firm is located in New Jersey, we assist clients in all of the 50 states of the United States. We also assist clients who are outside the United States looking to either come to the United States in on a for on a on an immigrant visa. So if you need our assistance, please feel free to call my office 973-993-1900, and you can follow us on social media: Facebook, Instagram, YouTube, TikTok, for as long as it lasts. And so that you can be notified when I come on. So I typically try to come on once a week, and I try to make it twice a week sometimes. I give I do a little presentation and I take some questions. So if you have any questions, feel free to put them on the comment section. I'm gonna activate my comment section right here, and I will answer the questions if I have the time and to the best of my ability. So I hope you guys are doing well. I haven't been around for like 2 weeks because I was sick, and you can still hear it in my voice. I still sound a little froggy, but I feel much better, and I'm excited to have this, give you guys share this topic with you. So we're going to talk about today. We're going to talk about VAWA denials. We've seen people come to our office who either filed their VAWA cases themselves or had somebody assist them in filing their VAWA cases, and their cases was denied. So I've been noticing the trend of the denial, and I want to talk about it so that you guys know what to avoid when you're filing your VAWA petition. And of course, I always recommend that you use an experienced lawyer when you're filing your VAWA case, because you really want to do it right the first time. VAWA takes a long time. We're looking at maybe 3 years now. And you want to be able to, you don't want to have to start from scratch or run into trouble in the middle, or get RFEs that make it just a little more complicated. So that's what we're going to talk about today: VAWA denials, how to avoid it, what are the things that could get your VAWA case denied. But to start off, I'm going to discuss, give you a background. What is VAWA? Because funny enough, even though I talk about VAWA a lot, I still have people who come for consultations who never heard about VAWA, who could have filed for VAWA, who could have gotten their green card through VAWA, but they didn't know. So let's go over what VAWA stands for and whether you qualify and how to qualify for it. So VAWA stands for Violence Against Women's Act. And that acronym suggests that it's, number one, only available to women, and number two, it has to be physical violence, both of which are not correct. VAWA is available to men, women, parents, children. It's not just available to women. And violence does not have to be physical violence. Yes, you do have to show abuse, and physical violence is one part of abuse, but emotional abuse, extreme cruelty, psychological abuse, verbal abuse, financial abuse, sexual abuse, on its own or together, can show that pattern of abusive behavior that would qualify for VAWA. So you may not, you don't need to have physical violence. You don't need to have a police report. You don't need to have hospital records. So these are the things that you need to know. First of all, let's talk about people that can file VAWA. If you are married to a U.S. citizen or green card holder, and you're in a bona fide marriage, you suffered abuse, your personal good moral character, and all of that, you can file for VAWA. Now, remember that you can also file for VAWA if you're divorced from that person, but that divorce you can file VAWA within the 2-year period of the divorce. Now, if you're a parent of a US citizen who's over the age of 21, you can also file VAWA if you suffered abuse from that American child. And it can only be an American child. A green card holder child is not eligible to file for you to file VAWA. It has to be a US citizen child who is over 21. Now, if you're the child of a green card holder or a US citizen, and that includes stepchild, adopted child, within the definition of immigration law, you can also file a VAWA petition. And the common denomination for all of this is that you have to show that you have lived with that person for some period of time. There's no requirement that you have lived with them for any length of time, but you have to show that you have lived with them at some point. And even for married people, you just have to show you lived with them before marriage, after marriage, it doesn't matter. That's a new law that came out a couple of years ago. So now, like we mentioned, abuse does not have to be physical. This is really important because there are a lot of people out there saying, I don't think I can file VAWA because I don't have any injuries, I have no pictures, I can't prove this. You don't need all of that to be able to file VAWA. Your VAWA petition could rise on the strength of a solid declaration, which is your story explaining what you went through, okay? So we're seeing some VAWA cases being denied, and some of the reasons that they're being denied is, number one, the party, either the petitioner or the beneficiary, has to be qualified to be in that marriage. So I'm going to explain what I mean. So if you are the beneficiary, you're the person who's looking to get a green card through your US citizen or green card holder spouse, and you cannot show that you are you're single, right? And that you're in a position you're available to be married to somebody, then your case will be denied. And a lot of times where this plays out is where you have somebody who was married before, you have a beneficiary who was married before, and they got a divorce, and the divorce was not properly done, usually in their country. And USCIS questions that divorce. If you cannot authenticate that divorce, you cannot prove that that divorce was properly done and that you were properly divorced, your subsequent marriage to a US citizen or green card holder is void, which means that that marriage does not exist, right? And you can get no benefits from that marriage. And a lot of times we see people who didn't even know that the divorce decree was not properly done because maybe their spouse in their country divorced them. USCIS really they don't buy that argument. So what you need to do is, if you're getting ready to get married to a US citizen or green card holder, and you've been divorced before, and that divorce is not an American divorce, and it's not a divorce from a country that USCIS does not question the divorce decrees, then you want to make sure that you authenticate that divorce before you get married. However, if the petitioner, that is the US citizen or the green card holder, is the one who was not properly divorced, and you didn't know, and you were involved and it was a legitimate ceremony, right? There is an exemption that allows you to proceed with your VAWA case, even though your spouse, your US citizen or green card holder spouse, was not properly divorced. It's called the bigamy exception. So if you're not properly divorced, what it really means is that you're still married, and then you married somebody else. So note that it doesn't work for you if you are the beneficiary, I say beneficiary because sometimes there was a prior petition, but I should use the word if you are the immigrant looking to get immigration benefits, right? It doesn't work if you are the one that wasn't properly divorced. Now, what do you do if that's the case? Well, in some states, right, when you file the divorce, it activates the marriage again. In some states, I think there are like a few states, one of which is Texas, right? However, you still have to show that that the abuse occurred during the marriage. So if you're still with a person and new incidents of abuse happen, then that could be helpful. Now, if you are in other states such as New Jersey, unfortunately, you have to properly divorce the first person, annul the second marriage, right? And remarry your abuser, which typically is really tough, which is the reason why if you're filing a VAWA case, you really want to make sure that you really want to make sure that you are properly divorced so that your marriage is not your subsequent marriage is not voided by law. Okay. So now there is a requirement that you prove that you and your spouse, or you and your parent, or you and your child have lived together at some point. And how do you prove that? Well, if in a spousal relationship, you can prove that by showing that you have a lease together, or you have a landlord who's willing to write that both of you have lived together, or you have evidence of commingling of funds showing that both of you have been living in the same at the same address, right? You can do that. Sometimes you can also get affidavits from family and friends who can vouch to the fact that you've lived together. Your neighbors, if they can write an affidavit saying that you are their neighbor, both of you have lived together for this amount of time. And the important thing about affidavits is it's really only helpful if you give enough information. So if you write something that really doesn't give the information that the USCIS is looking for, they won't give that affidavit much weight. Affidavits generally don't have a lot of weight, but if it's very detailed, very specific with dates, times, and events, right, and it's notarized, right, showing that the person who signed it before notary public to confirm that that's the person, then that really helps. So, so the proof of living together is one thing that you want to show to avoid a denial of your VAWA claim. Another thing that you need to show, you need to have to avoid your VAWA case being denied is you need to prove in a marital situation that it's a bona fide marriage. And a bona fide marriage means that you entered into this marriage with the intention of living with this person, having a life with them, and not only for immigration benefits. And that can be a little tough because a lot of times in a situation of domestic violence or abuse, it's really hard to get that information if your spouse is intent on not giving you documents. So what do you do if that's the situation? Well, you think outside the box. That's what we do, and that's what we're really good at doing. We think outside the box because the VAWA requires credible evidence. There's no requirement that you must submit A, B, C, D, but if you have credible evidence and you can explain why you don't have certain documents, that would really be helpful. Now, another thing that can get your VAWA case denied is not being able to articulate the abuse you have suffered. VAWA requires you to show that you have suffered abuse. And how do you show that? Well, you have to have evidence of it. Sometimes if you don't have physical evidence, like if it's not a physical abuse situation, you don't have pictures, you don't have hospital records, but what you do have is your declaration, your story. And that is really, really powerful. So if you don't have physical evidence, don't discount the fact that your VAWA case could still be successful if you can write a powerful declaration that is specific to what you suffered, specific to date, specific to time, specific to the events. And what is really helpful when you write your declaration is you want to make sure that your declaration is credible and consistent. So you can't write one thing in your declaration which contradicts certain things you put in your forms. So you want to be careful about that because VAWA relies on credibility. So if you're not found to be credible in one instance, it is likely that they may not believe anything you have to say. So another thing that can get your VAWA case denied is getting remarried while your VAWA case is pending. Now, you cannot get remarried until your VAWA case is approved. If you do so, they're going to assume that you have abandoned your VAWA petition, right? And I've heard people say, who's going to know? Please don't do that. You don't spend all this time waiting for your VAWA case to be approved, for it to be denied because you got married. So it's best to stay on the right side of the law. You cannot get married until your VAWA case is approved, okay? Now, another way that your VAWA case can be denied is if you file your VAWA application past the statute of limitations, which would be if you file it 2 years after a divorce, then you're out of time and it's never going to be approved, never ever, regardless of what you suffered. Now, if you suffered chronic physical abuse and you reported to the police, you may qualify for U visa. Or if you suffered domestic violence in the home or even outside the home, you may actually qualify for a T visa, because we look for certain things in trafficking cases. So there can be trafficking even within the home. So the important thing is that you should actually talk to a lawyer that is experienced with humanitarian type cases, because if you don't qualify for VAWA, you may qualify for you may qualify for T, okay? And if you are a child under the age of 21, you may qualify for special immigrant juvenile status. So I have a question from Makon Traore that says, what does this mean? DHS does not agree to waive any regulatory or statutory bars other than applicability. This sounds like a boilerplate language that they put in some of their letters, but I would need to read the whole letter to be able to explain to you exactly how that what that means with regards to your context. But they're basically saying that they're not waiving any bars, against this case applying to you. I don't know why they have to say that, because they never waive it. So I'm not sure why they have to tell you that. So Peerless Jackie says, can we still file for VAWA even after the 10-year green card to get a citizenship through the 3-year rule when divorced soon? So Peerless Jackie, even though your question is a little and I want to say convoluted, but I think I understand what you're asking. So I'm going to answer it based on what I think I understand. So the first thing is, if you've gotten a green card, VAWA is not what you should be filing, because VAWA is to get a green card. Now, if you've gotten a green card and you're looking to remove your conditions, the conditions on your green card, because you got your green card when you were married for less than 2 years, then there is a waiver under the removal of conditions, which people call VAWA, but it's not. It's just that it's similar to VAWA in the sense that you can get the removal, you can get a waiver based on having suffered physical abuse or extreme cruelty. So that's what that means, okay? Now, let me understand if you have a 10-year green card, then you can apply for naturalization if you have if you're still with your spouse in marital union, 3 years, within 3 years of getting your green card, right? I think it's 90 days before the 3rd anniversary of your green card. So if you have a 10-year green card, and you're still living with your spouse in marital union, you can apply for naturalization within 3 years, right? 3 years of the green card. However, if you're not with your spouse anymore, you have to wait for 5 years. So if you're not with your spouse anymore, separated or divorced, not in marital union, you have to wait for 5 years before you apply for naturalization. Okay, so Mark Traore says DHS agreed to joint motion to reopen, but said that. So basically, what they're really saying is that they'll reopen the case, but if there's any statutory bars, maybe you're barred because you're out of time, you're barred because of some rule, that they're not waiving that. And that's it just allows them to decide whether they're going to, they're basically saying that they're not going to waive anything by reopening this case. So they're going to reopen the case, but it doesn't mean that if there are things that disqualify you, that they will agree to it. So reopening the case doesn't give you any more right than the fact that they are reopening it to review the case and make decisions on the case. But if there are any statutory bars, you're barred by statutes, some certain statutes, or there are any laws that bar you, then they have the right to use those in, making a decision on their case. That's what that means. Okay, Makan Traore, I hope that helps. All right, so guys, I think that's it for today. I will be back again next week, and we can discuss some more immigration stuff. In the meantime, if you have any questions, feel free to put it on the comments. I come back and I look at the comments, and that could be the basis of a new live. Okay. Well, until then, take care and have a great week.